McDonald Senior Apartments versus Leeman Jones, Enrique.
Here, I'm requesting your hearing on behalf of Plaintiff.
Mr. Jones, please state your name, correct?
Leeman Jones.
Okay, we're for a bench trial with proceeding.
They do a jury trial.
Yeah, well, note for the record that, the jury trial, the man was late by law, and, therefore, you missed your window to have a jury trial.
You said by law. You said that I supposed to ask the first judge, right? You was the first judge. And
I never saw you on this case.
I was on Zoom. But then you know.
I understand what you're saying.
So
How just a second, Mr. Dunn. Every landlord tenant in this case, the first judge you see is not Judge Gross, Judge Walker, or Judge Bowie. You see Judge Jordan. So you did not see me. Judge Jordan is a white male and I'm a black man. You did not see me.
And I know that.
Okay, so that's your first court hearing in which you must make your demand.
Listen to what I'm saying. You're not even listening to me.
I'm listening, but I'm listening to you, but I'm correcting when you're wrong. So go ahead. You just said you saw me. I said you never seen me the first time.
That's what was on the paper. Okay.
Okay,
Bowie. Right.
that's on all the papers, but
No, that wasn't on all the papers, because the next paper I got was from Jordan. What I'm saying is, I asked for the jury trial. I paid for it. The first judge did not read me my rights. I don't care who he is, who he was, whatever. I'm believing it was you. You understand what I'm saying? So, and he dismissed the case. So now, why would I ask for a jury trial and be past my law or whatever you say if he dismissed the case? What I supposed to do? Then the next time I come to court, I'm in front of Jordan. I asked Jordan what I'm here for. He don't even know. He said, well, I'm putting this case back to Ruth. That's all. That's got stuff.
so for the record, be clear. 1/21/26, hearing termination of tenancy held. Plaintiff attorney was lost on Zoom, reset. Pretrial scheduled to February 2nd, 2026, 1:10 p.m. Judge Jordan. Notice appeared issued. They gave me Judge Jordan's on. February 2nd, pretrial held from Judge Jordan. And then on the 4th of February, you met with Judge Jordan. It was, I guess there was no agreement. You guys couldn't come to an agreement. So after that pretrial hearing, it was sent to me. And then we had a hearing for a bench trial. I said a bench trial for March 18th. You were on Zoom. You were supposed to be in person. That was a clerk error. And that's why we rescheduled the bench trial to today. So
I'm just trying to get it clear. How can I be involved?
but once again, your first hearing, per the law, you have 5 days to file your jury demand. You can file it with your answer or 5 days after the first hearing.
And I'm saying, Your Honor, again, he threw the case out. So why would I? That's what he ain't reading no rights. He didn't tell me that I had the right to have a jury or none of that. I read that from the paper.
Well, you know what? We can just pull the recording. I mean, you read it from the paper. There's a PowerPoint. I think there's a Zoom room. There's a recording.
My understanding, Judge, and I don't get to hear the video of Pontiac because my understanding is if I listen to the clerks, they play the video before the tenants come into the courtroom, so to speak.
So that's the process of this court. You're advised of your rights. You watch the video. You're told to watch the video. Get the form. You come in. You got a chance to meet with the judge. It's like when I take a criminal plea, I go on a long speech and spiel about, do you understand your rights? Do you have any questions? Standing at that podium, You can tell me your attorney's threatening, like anything, so I don't believe you were uninformed about your rights. You was,
Of course, what,
Yes, sir, you need to be near the mic.
yeah, you
At
need
the
to be
podium.
near the mic, or go to the podium there with that black mic right there. You need to speak close to it. All right, Mr. Stratton, you want to make an opening statement?
Just briefly, Judge. Judge, you're gonna hear testimony from both the property manager and the maintenance man. You're also gonna hear voicemail. This is a case that was brought for termination regarding threats made to the community manager, which is a violation of the lease. And we believe that after you hear the testimony, you see the exhibits, and well, most importantly, your voicemails have been left over the course of a couple of months, including but not limited to, I think most recently this morning. You will find that Mr. Jones has been acting in violation in terms of his lease, and that termination of his lease, his tenancy will comply to.
Mr. Jones, you have a chance to make an opening statement.
Well, I don't believe that they can, do nothing by no statements. And, cause she already made a police report and made some more foolishness. So I don't believe they can prove their case. I really don't. You know, because first of all, it come from her tape. And whose tape is that? That he talking about putting on, putting up here. Second of all, we don't know, where them tapes come from, or them statements that they saying they got. I don't know where none of that come from. I can't verify where it comes from, and you can't.
Okay. All right. Any other statements you want to make, Mr. Jones, before we call the first witness?
Like I said, I'm objecting to this whole thing because I paid for a jury trial.
Oh, you're
I mean, so I'm gonna allow this to go, because
I
I gotta do what I gotta do.
no, I would
So I got to be here, so I'm here.
understood.
I'm all the witness.
I mean, I think we've been pretty clear about
Yeah,
the deadline.
we good. All witness.
All right, and it's just, and Mr. John, I just want to respectfully remind you that I am Judge Jeremy Darnell Bowie, sitting in this court. There's a level of respect that you will give this court, or we just go, I'm gonna have to do what I have to do. So disrespecting me, yeah, let's go on, let's get on with this, all that. I don't need all that. Okay? Thank you. And I'm not gonna repeat myself. I'm not tape recording, so that's your only warning. Mr. Stratton, you want to call your first witness, you may?
Thank you, I call Akita McClarkin.
You will come to the witness stand, Mr. McClarkin, and then raise your right hand. Raise your right hand. Do you swear or affirm subject to the payment of bills of perjury testimony you give this court will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Before you start, state your name, spell it for the record.
Akita Mcclarkin, Akita McClarkin, McClerkin.
All right, you may proceed.
Thank you. Mr. Clerkin, who do you work for?
For Volunteers of America for McDonald Senior Apartments.
What's your position at McDonald Senior Apartments?
The Community Administrator,
In that position, are you familiar with the books and records of McDonald Senior Apartments?
yes,
Are you familiar with how the books and records are kept?
yes,
Are those kept in the normal course of McDonald Senior House business?
yes,
And then they kept by individuals who are familiar with how to keep the books and records at McDonald Senior?
Yeah.
And people who are familiar with the policies and procedures of the McDonald Senior Apartment?
yes,
In our entries, for issues entered or logged into the system at or around the time the event occurs, i.e. if rent is paid, you log in, not a date, if rent is due, you log in, and things like
yes,
that.
yes, well,
Okay. And you are competent to testify about the books and records of the McDonald Senior House?
yes,
Are you familiar with the matter of the Leeman Jones matter?
yes,
And prior to this appearing in the workday, you had an opportunity to review the file with the
yes,
Okay. And Mr. Jones is currently a resident at McDonald Senior Housing.
Yes.
And I'm gonna, and Judge, I don't apologize, I kind of just slapped these exhibit tabs on here, a little willy-nilly, so if they're gonna be a little out of order, I apologize. So I'm gonna start with, if I want to approach the witness, I can't both exhibit 2. That makes any sense to you. Now, I do have copies for Mr. Jones, and I'm providing him with copies as I come on. And Judge, you want a copy to go along with as well?
And once it's submitted.
Okay.
So that's plaintiff's, proposed exhibit 2.
And then the lease, Judge. Mr. Mcclarkin, you identify the document you're holding in your hand.
Yes.
What is that?
It's the lease for Mr. Jones.
This is the lease that's between McDonald Senior Apartments and Leeman Jones.
Yes.
And what date was this lease entered into? If I look back on page 10 of the document.
Yeah, April 7, 2023.
And this is a lease that was signed by both parties.
Yes,
And this was the lease that Mr. Jones signed when he took possession of the property.
that is correct.
And this is the lease that he's currently residing in, pursuant, this is the lease he's residing under at McDonald Senior Apartments.
Yes,
And this is kept as part of Mr. Jones's tenant file.
yes.
Your Honor, I move to amend plaintiff's proposed exhibit 2.
All right, Mr. Leeman, plaintiff's, proposed exhibit 2 is a copy of the lease. Do you recognize that? Do you dispute that being your lease? All right, so you don't object to it being entered into evidence for me to review? Submitted.
Thank you. If I might report you.
Yeah.
Do you want the copy, the sticker, or do you want this is, okay.
It's all coming back to you.
All right. Thanks, Judge. Ms. Jones, this is the lease that Mr. or Ms. McClarkin, this is the lease that Mr. Jones is subject to during his tenancy in McDonald Senior Apartments. Is that correct?
Yes,
If I might draw your attention to, page 2. This is paragraph 8. Discuss the provisions by which a tenant can be terminated, the tenancy can be terminated to LC limits.
yes,
And I want to particularly draw your attention to page 3, looking at paragraph 8, in subsection 1. And if I look down, maybe about the second sentence, starting with the paragraph, this termination must be based upon either material, you see what I'm talking about?
yes. Non-compliance with this agreement, so your failure to carry out.
Yes, if you could just read that on the record.
This termination must be based upon either material, non-compliance with this agreement, material failure to carry out obligations under any state landlord or tenant act or criminal activity that threatens the health, safety, or right to peaceful enjoyment of their residences by persons residing in the immediate vicinity of the premises. You want me to read the whole paragraph?
If you could just finish up by where it ends about the property management staff.
Okay. Any criminal activity that threatens the health or safety of any on-site property management staff responsible for managing the premises.
Fair enough. So pursuant to the terms of the lease, it refers to terminating a tenancy based on violation of threatening the staff or management of the community. Is that correct?
Yes.
In addition to Mr. Jones signing the lease at McDonald Senior Apartment, he also signed house rules that applies to McDonald Senior Apartment too. Is that correct?
Yes.
Okay, approach the witness, Your Honor.
You might, that's what exhibit what?
Be 3. Sorry, Judge.
You
They let anybody go to law school?
said all of the rules, proposed rules?
Yeah, these are McDonald Senior Apartment Community Policies / House Rules.
You may proceed to block hearing her over that.
Thank you, Judge. Ms. Clerk, can you recognize this document?
Yes.
And what is this document you're holding?
The community policies.
And, these are the house rules / community policies for McDonald senior apartments,
Yes, that's correct.
and all residents are provided a copy of these?
Yes,
Mr. Jones provided a copy of these?
yes,
And in fact, if you look on page 23 of this document, you can find the signature page.
yes,
And on that signature page, it indicates that it's an agreement and acknowledgement.
yes,
And does Mr. Jones' signature appear on that?
yes.
And what's the date of that?
4/7/23.
And that would be the same date you took the
Yes.
He signed his lease. Is this document kept in the normal course of business at McDonald Senior Apartments?
Yes,
And this is part of Mr. Jones's tenant file?
yes,
You're already doing it, plaintiff proposes exhibit 3.
Mr. Jones, he gave you a copy of the McDonald City Department Community Policy / House Rules. Do you recognize that
I
document?
do.
All right, did you sign that document?
Yes, I do.
All right. So no objection to it, admission?
No, no objection.
Okay, it's admitted.
But for adjourn?
Right.
Sorry, John.
To exhibit 3, Mr. McClarkin, if I might draw your attention to page 4 of this document. And specifically, I'm looking at page 4, paragraph B and C. If you could read paragraph B into the record.
residents and his or her guests will not engage in or participate in such conduct which interferes with the quiet and peaceful enjoyment of other residents living in the apartment property. No act of a resident and or guest which threatens, intimidates, is deemed as harassing others, is physically violent with or without injury to another person and or property, or has unacceptable social conduct will be tolerated. Any such incidents will be considered a violation of the community policies and the lease agreement. Additionally, where applicable, such incidents will be reported to local law enforcement.
And then if you might read paragraph C into the record.
Acts of intimidation, harassment, including sexual harassment, verbal abuse, physical threat, or violence, or social misconduct of or to any employee of the property by any person will not be tolerated. Any such incidents will be considered a violation of the community policies and the lease agreement. Additionally, where applicable, such incidents will be reported to local law enforcement.
Mr. Jones was provided a copy of this,
Yes,
and presumably aware of the House rules and community policies.
yes.
We brought this action was filed, because why?
The voicemail that I received in December.
So your testimony is you received voicemails in December.
Yes.
What was the voicemail that you received?
Voicemail basically state that if I don't get my shit together, that somebody's gonna get fucked up.
Your Honor, if I might,
Sorry for my language.
No, you can state exactly.
Okay.
And Judge, if I might play, I think I've got 6 voicemails altogether. We're gonna play. If I might play the first one, Your Honor.
You may turn it loud and put it close to that mic, because Lizzie Leo is going to the transcript she has to do.
Okay, we'll see how this works. It's your testimony, Mr. Did you hear that, fine, Judge?
I did.
Okay. Mr. McClarkin, is your testimony you received that voicemail on the McDonald Senior Housing voicemail?
Yes,
And who did you receive that from?
Mr. Jones.
And how are you able to determine this, Mr. Jones?
The phone number.
The phone number that you received it from tracks, it matches the phone number that you have about Mr. Jones'
Yes.
office? And how did you take that, how did you perceive that, that message?
I
So
meant,
is that being admitted to evidence?
Oh,
Yeah, we kind of,
all right. Let me,
yeah, let's,
Your Honor, I would move to admit plaintiff's proposed exhibit, that would be 6, into evidence.
all right.
So I'm
So
gonna have, I've got a couple of the written documents that I'm gonna introduce, so that'd be 6.
any objection, Mr. Jones?
I object because it's not threatening. I ain't threatening her.
Well, let me just ask this. Did you recognize the voice on that voice message, Mr. Jones?
I did,
Was that your voice?
yes.
All right. And you're not disputing that you left that voicemail, you're just disputing that it was not threatening, is that correct?
You know, I'm disputing because that's showing sent him half of it.
All right, so we're just trying,
You know
Get
what I'm
that one.
saying? It's another part to that, but what's on there that she ain't, I ain't here.
Do you have it?
He better have, I hope he have it.
I mean, but,
I mean, I,
so I'll admit, we can admit that voicemail, and he didn't object to it being his voice,
no,
and he didn't leave it. He admitted that he left the voicemail, he recognized the voice, so.
yeah, I admit that, George.
So
I
that's,
subjected to that.
that's plaintiff's exhibit 6, right?
That's correct, Judge.
So, yeah, we just gotta lay the foundation, that wasn't done.
Sorry, I jumped the gun there. Ms. Mcclarkin, when you heard, and when you picked up, listened to that message, when you listened to Exhibit 6, what was your thought? What was your feelings in regard to receiving that?
Took it as a threat and made a police report.
Because the message indicated that somebody is going to get fucked
Yes.
up, is perceived it as a threat.
Yes,
And as a result of that, you indicated what?
made a police report.
Your Honor, I'm going to approach the witness.
Yeah.
I'm handing the witness what's been marked as plaintiff's proposed exhibit 4.
And that's, what is that?
It's not exactly a police report, it's just a record of the police report being made, Your Honor.
Can you identify this document, Mr. McClarkin?
That's the little card reader from when I went to the FOIA website to print off the police report.
I'm sorry, Judge, did I say 4?
Yes,
That's 1. That's my bad one. You indicated this is when you made a police report?
Yes,
And up in the top, kind of top right-hand corner indicates the date this was taken.
yes, December the 15th of 2025.
So upon receiving the message, you contacted the police shortly thereafter.
Yes,
And this is a record of the, this doesn't indicate any action that was taken on behalf of the County Police Department, but it just indicates that you didn't back file a police report.
yes,
And you filed a police report because
yes, due to the voicemail, the threat was left on voicemail.
and is this document kept in the normal course of business at McDonald Senior Apartments
Yes,
and is kept as a part of the file for Mr. Joseph?
yes,
Your Honor, I move to the plan proposed exhibit 1.
you got the copy of that, any objections, Mr. Jones?
No, Your Honor.
All right, and that's to the Oakland County Sheriff's Department, correct?
yes,
Like, it's no longer half on behalf of the department.
yeah.
If I might approach Your Honor?
You may.
In addition to filing a police report based on the voicemail, at that point, did McDonald Senior Housing have any thoughts and/or any thoughts as to Mr. Jones's continued tenancy at McDonald Senior Apartment?
I contacted the attorney's office to do the legal paperwork.
Sorry, what was it?
Termination tenancy, termination of tenancy.
If I might approach Your Honor? The witness?
You may.
I'm gonna hand you what's been marked as plaintiff's proposed exhibit 5.
You know that.
It's the notice of quit to recover.
And this notice to quit was prepared and sent by not your office, but by your attorney's office file. Is that correct?
Correct.
And the date this notice was prepared,
December the 18th.
and it was, and as this document, even though our office prepared it, you kept it in the McDonald Senior
Yes.
records.
Yes, that's right.
There's in Mr. Jones's file.
Yes.
Your Honor, I move to amend Lance proposed exhibit 5.
Any objection, Mr. Jones? No, Your Honor. All right, so maybe,
And Your Honor, may I approach?
we want.
I believe you may have a copy already of my file, but.
Yeah.
I know it's exciting to hold my paper. Mr. Mcclarkin, did you, indicate, so in exhibit 5, it indicates, the basis for termination in paragraph C can identify, to the court why, this 30-day notice was sent?
Tenant made verbal threats. It says to tenant made verbal threats to do physical harm to management staff, which resulted in police being called.
And again, this was issued on 12/18/25,
Yes,
and that was giving, this was 7-day notice that it gave Mr. Jones, 7 days to vacate.
yes,
And then this notice that was indicated paragraph D, until 12/26 to kind of vacate.
Yes,
And Mr. Jones, did he vacate?
no,
Still continue to reside there?
yes,
And as a result of the voicemail of 12:15, that's why you.
Yes. yes,
And subsequent to receiving the initial voicemail from Mr. Jones, is it fair to state that you received several subsequent voicemails from him as well?
yes,
Your Honor, if I might play plaintiff's proposed exhibit. This will be 7, 8, 9, 10, 11, 12, 13 in order of voicemails.
Exhibit 7 to 13.
Yeah, the additional voicemails left by Mr. Jones. If I might play proposed exhibit 7.
Yes, want to authenticate it though. Play a little, well, after each one, you know, we'll do.
We'll go
so
to that.
you- You'll play a little bit of it. She'll say she recognizes it, and then we'll go from there. I'll let you. All right, ma'am, you recognize the voice in that?
yes.
All right, and do you know when that voicemail was sent?
That voicemail, well, I have voicemails that were sent between December to current day, to March.
So it was sent between December and today.
Yeah, December and last Monday.
We may not have the exact dates, but these are a series of voicemails left over the course of the past 3 months.
All right, and those voicemails were sent to the community phone or your office
The
phone?
office phone,
All of those 6, 7, all the voicemails were sent to your office phone?
office phone,
And they all came from a number identified as Mr. Jones's phone number.
yes,
Okay. All right, we're satisfied with global laying of the foundation
Okay, for 7 through 13.
or 7 to 13.
Okay,
Right, as
So-
long as she recognizes the voice, that's okay.
okay.
So they'll be admitted. Any objection, Mr. Jones?
I don't object to it. Only thing I object to it, like I said, is whatever that thing is saying, it's a front part to that too.
All right.
You know what I'm saying? But I'm not objecting. Go ahead.
And how were they downloaded from the phone? How does that work?
I just pushed, the download button to forward out to his voicemail, so on the Ring Central, we have Ring Central, it's a download button, and I can forward the voicemail to his email.
Okay, so you forwarded them all to Mr. Novak. Were they altered in any way?
No.
Did you snip them? Did you
No.
trim them down?
No,
All right, so plaintiff's exhibit 7 through 13 are admitted.
Thank you, Your Honor. I was kind of play them in order here, and I'll maybe ask the questions in between.
Okay.
So that's one of the voicemails that you received.
Yes.
And again, what is your feeling or belief as you are receiving these voicemails?
but just the same basis that you feel like that he did not make no threat, and based off the community policies, I deemed it as still the initial threat from December. Although no person was identified, just saying that someone is going to get fucked up.
And you got to see some second by personal acts of intimidation, harassment, verbal abuse, physical threats. It's not just limited to threats. There's the variety of issues under the community standards that this is problematic under that.
Yes.
Next one, Judge.
That's number 8.
Yeah, this would be number 8. Sorry, my phone. Let's do it back here, Judge. And again, in that one, he indicates that, quote, you have a problem. How did you perceive that phone call or that message?
On the same basis, doing some type of sorts of intimidation with, along with the December, voicemail.
I object to that.
You have a chance to cross examine, go with objection overruled.
And then the last one, there would be exhibit 9. Well, then, the last of this, I'll have a few more after this one. And this one, he indicates he's going to squeeze you like a grape.
Yes.
How did you perceive that?
Well, that just sounds very threatening, so I don't know how else to perceive when somebody says squeeze you like a grape, what's up, vitamin C or so.
These voicemails were all left after he received the 30-day notice. Is that a fair statement?
Yes.
The next one will be exhibit 10. And I believe we know that these ones are from, is this from March 23rd, just after, just before, or just after court date, or prior?
Yeah, we have court on March 23rd.
Okay. He's referencing a couple of voicemails, the term chili pepper. Do you know what he's referring to?
The maintenance staff.
Your maintenance man, is
Yeah,
Flores is here today?
Yeah, this is Flores.
This one judge will be exhibit 11. In addition to the, what you perceive the threatening or intimidating in nature of these phone calls, are they also affecting, your ability, and your staff's ability to effectively manage the property?
I object.
Here's the objection of all speculation. I don't know. What's your objection?
Because he trying to lead her in the sand that,
Well, I get it. So your objection is leading, so I'll sustain and rephrase.
Thank you, Your Honor. You testified that the phone calls and voicemails are threatening and intimidating in nature. Are they having any other impact on the community or your ability to manage the community?
Well, as of recently, with all the voicemails and the ongoing voicemails of harassment, because I consider it to be harassment, that I've contacted the police last Monday because Mr. Jones was outside of the office and outside of the building during the course of time that I'm still in the office hours. So that was on that Monday, and then that Friday before we had court.
What occurred that Friday before we appeared on court on the 18th?
I was at the office late, so I worked late that evening, doing some paper, finishing up some paperwork. So between the course of time from 6 to 9 o'clock, so I didn't leave work till like 9:34. He was from the front door area, because it's only one door that I go out of and come in. So he was out that door, and then right at the community room doors, right by my office.
Typically, does anybody sit outside your office doors for hours on it?
No,
And because it was Mr. Jones, and the irate of the case, he felt.
there was an intimidation factor.
And then there's 2 more voicemails. I believe these were received, when Mr. Mcclarkin?
I think the last 2 voicemails would have been the same day, 3:23, after 4 o'clock, after we had court, because we had court at 2:30, and those voicemails would have came in about 4:45 and 5, a little after 5 o'clock.
It's received on 3/23, March 23rd,
Yes,
4 months after you submitted the, notice to quit for threatening behavior,
yes,
and the threats and intimidation in your mind continue.
yes.
And this will be the last question, object. This will be exhibit 13. Those are the voicemails that you say to send over, and again, your perception is what?
That is one, deemed as harassment, intimidating.
And in addition, at least to the first one, you felt sufficiently.
With the threats.
Contact the police department.
Yes,
And at this point, it's your request that Mr. Leeman's tenancy, or Mr. Jones' tenancy be terminated based on a violation of the lease.
yes,
That you read it for the record,
yes,
and also the community standards / house rules.
that's correct.
Judge, I have no further questions at this point.
Mr. Jones, you can step to the podium. You have the right to cross examine, ask questions.
It's gonna be brief,
You
man.
need to go to that podium or speak in that mic close to you, bring that mic close to you.
Oh,
It's
yeah.
right here, right here.
Podium now, if you don't mind.
Close to the podium.
It's gonna be. We first met. In your opinion.
I don't have any opinions on any residents or applicants.
Don't be now, right?
I know you because you're a resident at McDonald Senior Apartments.
So. I heard you state some stuff. Emails. Tapes. You know, every time I call you on the phone, it be for a reason.
You gotta ask questions. What is your question?
Let's be able to, what?
You've called on the phone because you accused maintenance of going into your apartment still.
And so if I called you and stated that on the phone, that's giving you a date and time, right?
Yes, you,
Did you report it down? Did you make a report?
I've also,
Did you?
Hold on a second, Mr. Jones. You ask one question, be quiet, she'll answer, and then she'll remain silent as you ask the question. So ask your question.
Did you make a report?
a report,
Yes.
no report.
Did, make this man make a report?
A report,
Written report.
Maintenance have put in reports on verbal things that were said to him per you.
Where
I have them over there because I did not bring them to submit them in for court for things that you said. I based it off the voicemails that you left.
back to I'm done with voicemail stuff. I'm gonna move on to something else. You made a police report. Fifteenth, right?
Yes,
In December 2025.
yes,
And he's on 2025.
yes.
Every day. We understand what's going on.
So you're trying
I'm giving her lawyer a police report that she's filed. She already testified that she
to,
filed.
right, I understand that there's a procedure in which you get paperwork or documents to the witness. So
Oh, I'm
so you're
sorry.
giving it over to Mr. Stratton so he can review the police report to hand it over to Ms. Mcclarkin, correct?
Yeah, so she read it to you and I.
She not gonna read it into the record. You're gonna ask her questions based off of that report.
Okay, I'll do that.
And he will facilitate getting documents from you later, Ms. Mcclarkin. You
Okay.
won't.
I understand.
So, Ms. McClarkin, are you familiar with that police report?
I haven't seen this copy. They when I went to the FOIA website, they gave me the redacted information that that the attorney submitted in.
All right, so you've never seen that full?
No, not the full report like this. No.
All right, so she's never seen that police report, so there's no way she can get his evidence. So what's the purpose of the police report?
She went to the police station and made the report.
Right, but she said she never physically got a copy of the report. So she can't testify to the contents of the report. You know. She can testify that she went and made the report, but she never physically seen it or reviewed what's in the report. She can't adopt whether it's true or not.
Well, that's why
You can ask her questions about, did she go to the police station? Yes.
Okay, well, I'm giving her a chance to read it and then I to the question.
It's fine, but yeah, you can read on it.
Okay.
Allow her to read over it. She's not sure. Let us know.
Okay.
Or you may proceed with question.
The officer put the wrong name down there. George was a previous resident.
So. Officer Jones. Exactly what you sent him, right? As far as the report. He states in the report that he sent you a report to and report card to file back to him. And you said that you had statements,
Right.
right?
So
That's in the statement. right?
so the police officer does have written statements and then they have the voicemail, they listen to the voicemail
So,
in the substation.
no, hold on. So you left work at 1,600 hours and went to probably over here to the station, correct?
I was already out the office.
At 1,600 hours is 4 o'clock.
4 o'clock, I was already out the office.
Okay, so you just reluctantly went to the police station and made your little police report right here, right?
Yes, I made a police report.
You see, it says on there, body cam active.
Yes,
Okay. So that means that Officer Jones recorded everything that you said.
I cannot say
I guess
that.
I'd object to that, Judge. The report may say that, but Officer Jones isn't here to testify to that or indicate.
Well, I'm just saying.
Well, hold on one second, Mr. Jones. Let him finish. You can't talk two people at one time. Go ahead, Mr. Fisher.
He is a, the report may say that Officer Jones isn't here to testify whether his body camera was on or was not on. I've never seen the body camera footage. So the fact that it may be in the report isn't indicative of its truth. Not that I don't believe that police officers are truthful or court officers. It's, I think that, that's what it says. What Mr. McClarkin knows about it is something totally different.
So yeah, she doesn't have knowledge of whether it was active, not active. She didn't review any body cam, so as far as I know, it doesn't exist until it's approved otherwise. So do you have body cam video with you, Mr. Jones? Because I don't have, they don't have it. Do you have it?
Officer Jones got it. I mean, listen, this is all I'm saying, Your Honor.
So I'll rest sustain the objection. There's no evidence of it. I mean, it's just in the report.
Well, I'm saying, she testified that she filed a report on December the 15th of
Correct.
25.
Correct.
That is the report that she filed. That's what I'm saying. I'm trying to get her to understand.
Right, but if she hasn't seen the report,
She's seeing it now.
right, but this is the first time she's seen
And we would stipulate that she filed a police report on the 15th
it.
of.
Right, they're not contesting, sorry, that no police report was filed. They're saying the police report was filed, but she never seen it
You
either.
said I can't question her about the police report that she went and filed to try to boost her case against me with you.
I am allowing you to ask questions about the police report, but you're asking about body cam. She doesn't have control over the body cam. That's evidence you can't get out of this witness because she didn't create the body cam. She's not the custodian of body cam. She knows nothing about the body cam. You could have foiled the body cam if you wanted to.
No, I understand though.
So I'm saying,
I'm saying, I understand that she don't understand. I don't even understand about Cam, to be honest with you, Your Honor. But I'm just saying, it said it was active. That means during their conversation, whatever was said was on the body cam.
I
Agree?
I don't know whether
Agree?
or not it
That's
was.
how body cams work.
I'm very aware of how body cams work, but
Okay.
what I'm telling you, sir, is that she can't testify how it works.
I ain't asking her to.
All right, so you can't ask her about anything on the body cam because she don't know. You ain't seen the body cam video. You have not seen or reviewed body cam video.
No, the only reason why I mentioned the body cam was to let her know that it was active. So what she says in that paper right there is on body cam.
Okay, that's absolutely great.
You know what I mean? So
But the evidence of the absence is evidence of the absence. I know that's probably a little difficult to understand, but that evidence is absent. So it's irrelevant, immaterial to me. So you may move along. Yeah, okay, the body cam was on. She's never seen the video. I've never seen the video.
Me neither.
You haven't seen the video.
No,
So
I
we
won't
talking
see
about
it.
something we haven't seen. Well, you had a police report. You pulled this police report out. Did you read over it?
I read the whole book
So you saw it was body cam. How could you never inquire about the body cam?
because
That's not your attorney. That's not your attorney.
my attorney.
That's not your attorney. When you come in here and want to swim with the sharks, you're gonna have to learn. I'm not calling the sharks here, but
I understand.
you need an attorney. If you had an attorney, they would have read it, watched the body cam, And they would have read the police report, saw body cam, would have said, you know, I'm kind of interested in seeing the body cam.
Okay.
But because you have an attorney, you're pro per, that means it's
Right.
your job to do that.
So just like I thought that I was supposed to, well, I ain't gonna get into that. Can I get from that paper? Paper back.
You can have that. All right, so you got any more questions?
Yeah, cause she, you know, I can't use the police report that she filed, that she just testified to that she owned.
You could question based off the content of it, but you're asking about a body cam. You're saying the body cam was on, right? She never seen the report.
And I understand that
You
part.
get what I'm
And
saying?
I started to ask for the body cam too. I started to.
Okay, well, you got any more questions for Mr.
I
McClarkin?
got some more questions.
Hey, Judge, I would just say, for the purpose of this police report, I would say that I stipulate to what the police officer, I stipulate this is what the,
Mr. Jones? Quiet. Go ahead.
I stipulate that this is what the responding deputy indicated in this report. Whether or not it's accurate, I can't testify that just Officer Jones is here. So I will stipulate the report says what it says, but I will not agree that it's,
Right, understood.
Minnesota.
Go ahead, Mr. Jones. Keep trying to talk to someone else is talking, I'm telling these guys one at a time.
I'm gonna speed this on up, John.
Thank you.
In this, don't give, no dates. You know, you said, I'll just get to the details. Police asked you one question in this report. And I just, you know, to hear what you got to say, and I'm gonna rest after this one. I got stuff like that. He asked you, he said, what did Mr. Jones say? What was your answer?
What did Mr. Jones say as to what?
He asked you after you had provided him.
So, how about you say what she said and say, do you remember making this statement? You remember answering the officer's question in this manner?
Right. So, Mr. Craig, Officer Jones, you remember making this statement to Officer Jones? Do you remember making a statement? Akita said that Leeman has been calling the office, making threatening statements and being rude. Right?
I told the officer that you have been calling the office, leaving threatening voicemails.
This is the officer speaking now. He said, ask Akita what was said. And she said that Leeman stated someone was going to get hurt. You made that statement, right?
I told the officer that you said that
Yes,
somebody was
no.
going to get fucked up.
Yes or no? Did you make
No.
that statement? To
No, so what I said was that somebody was going to get fucked up.
That ain't what this said.
Well, see, move on.
And I'm gonna be going. And then, this the good part. You made the last statement you said in this report. I'm gonna ask you, did you say this first?
Yeah, Judge, I would just object, because this is the police officer's, this is the police officer's perception of the conversation. This is not we don't have the money, can't, we don't have the recording. This is just the police officer's perception of what my client said. So I object, here's the evidence.
All right. I was sustaining objection. You can ask Ms. Clarkin what she said. And objection, if you watch any kind of legal show, Law and Order, Suits, NYPD Blue, all that, Mr. Jones, you up here mad when the attorney objected.
Man.
You just doing all this twirling, you guys
I
don't
can't
have to do
believe
that.
him saying, I can't believe him,
Finish with your question. You could ask her what she said. There's a statement that she made there.
I mean, she made a statement, you know what I'm saying?
I'm asking you, you referring to the police report, like you're about to say something. Did you say X, Y, and Z? Do you remember stating that? You can say that. What were you about to ask?
Did you state that Leeman was having issues with George?
I told the officer, he asked me what happened in the history of what transpired. I told him that Mr. Jones had an issue with Mr. George. They had got into some type of altercation, and Mr. Jones had got stabbed. And then after which, that's when we started having the ongoing issues.
Well, question here, why would George's name be in anything in 25 when he hasn't been in the building since he stabbed me December of 26 of 24? So why would he be in any police report dealing with maintenance in your building, which you state, well, like you said, I'm sorry. We don't know how the police, Mr. Jones did this or nothing, but you said right here, you said, he had, what happened, and you said that Peter said that Leeman has been accusing a maintenance worker, George, of going in his room and stealing his stuff. That's
What's your question?
my question is why? Why would you make a report about George being stealing my stuff?
The report wasn't about George stealing the stuff. The officer put the wrong name in the report because I told him that it was our maintenance guy. He was accusing the maintenance man of going to his apartment and stealing, and that he had issues prior to, and Mr. George was stabbed. Another resident was stabbed, and that resident was evicted. The officer wanted to know the ongoing history.
So you wanted to know the going over the history, but that ain't what, that's not what this is saying. This is talking about.
You got any more questions,
I
Mr.
ain't got.
All right, you may be seated. Any redirect?
No, no.
Mr. McClarkin, you may sit down. Any other witness?
One briefly, Judge. Enrique Flores.
First seen attorney, raise your right hand. You swear or affirm subject to the claims of the party testimony given is partly the truth, all the truth, and nothing but truth.
Yes, sir.
You may be seated right there. And you can start by stating your name and spell this slowly so this will be able to take it down.
My name is Enrique Flores. Enrique, last name Flores, Flores.
You proceed with the direct examination.
Thank you, Your Honor. Flores, what do you work for?
I work for Volunteers of America, McDonald Senior Apartments.
So you work at you actually work on site at McDonald Senior Apartments.
Yes, sir.
What's your position there, sir?
Maintenance supervisor,
And how long have you worked there?
22 years.
So, Mr. Based on prior testimony, Mr. Jones became a resident at McDonald Senior Housing in February of 23. Is that established?
Whenever they signed the lease, I have no part of that, but yes, he moved in on that date.
So you've been maintenance on staff at McDonald Senior Housing for the whole of Mr. Jones's tenancy at
Yes, sir.
McDonald Senior Housing.
Yes, sir.
And you're familiar with Mr. Jones?
I know of him.
What's your how do you know of him? What have you had any interactions with Mr. Jones during the time?
I had a lot of reactions with him.
A lot of reactions?
Yeah.
Or a lot of interactions. What are your interactions? What have your interactions been like?
I'm trying to do my job, and all of a sudden, he's yelling I'ma kill you, motherfucker. You punk bitch. You bitch ass motherfucker. You ratchet ass bitch. I'm getting called every name in the book. And all I'm trying to do is do my job.
So, and when did these, if you can recall, when these threats started?
Is it for basically right? Like it got started on me. It's been at least 6-8 months that this has been going on.
So 6 to 8 months, so going backwards from now, about 6 or 8 months prior to March of
To this day.
Okay, so even after the 30-day notice was set in this case on December 18th, that you still had negative interactions with Mr. Jones?
I have to change my way of working because I refuse to get yelled at, be called a bitch, be threatened. So I don't even go down that hallway. It's an enclosed building. So when I come out my office and he's like, yeah, that bitch ass motherfucker, I'm gonna kill his ass. I just turn and walk the other way and just try to avoid him at all costs.
And he's talking directly to you?
Yes, looking directly at me, telling me that he's gonna kill my motherfucking punk ass.
And you, do you feel threatened when he
Yes.
says? And does that impact your ability to work?
Yeah, it's making me not be able to do my job at the building.
Objection.
I avoid that side of the building or wherever he is at.
Sure, objection.
He lead me. He can't lead the man. He's leading him. He's leading him through testimony.
What was the leading part?
I think I asked if you felt threatened. I think that was the question. I guess I'll rephrase it. How does that make you feel?
No, that's okay. Do what you do.
How does that make you feel?
Threatened, harassed, not want to be at work.
But you come to work every day.
Mr. John. John, man, you way senior than me, man, but you way immature than me. It's crazy. Relax. Before you be relaxing downstairs, you gotta relax the Old County Jail.
And as you testified, it does impact your ability to perform your duties at the McDonald office.
Yeah, I changed my whole way of working. I try to avoid anywhere he's at all costs.
I have no further questions, Your Honor.
All right. Frost, you can stand up and ask a question.
We start having problems.
I never had a problem with you.
Against you. 3/13/25.
I have no knowledge of that.
No. Bring up back to. That's because the bug come in my apartment and spraying bug spray. 3/13/25. I filed
I'm just objecting. If you want to ask a question, that's fine. He's essentially testifying.
One, you're testifying. Two, this is beyond the scope of direct examination. So all that will restricting. You need to ask questions that was covered about the threats, sir. Threats, that's why we're here. Threats.
You said I threatened when what day?
I got it all documented.
Where?
They said they didn't bring it. They said they were going off of the tape thing. I got everything. I wrote it all down. Every time you told me you was gonna kill me, every time you called me a punk bitch ass motherfucker, every time you called my mama a white honky, everything you said to me, I wrote it down.
Well, where is that? Go get it.
Judge, can I go get it?
Yeah,
Judge, he's here testifying.
your testimony is done.
The judge says my testimony is good enough.
The judge, is this testimony good enough, Judge?
You don't have to go get that. I mean, the voicemails are, here's the deal. I'm gonna give you the opportunity to ask questions. You wanna ask questions about the threats, like, what are you doing, Mr. Jones?
like I said, he's standing out and threatening. He can't prove that, you know. I asked for a date when on camera something to prove what he's saying. And then I can't, you know,
You could provide the dates and times. This question is Mr. Jones.
you know, and I think what the date and time. That's what I want to know.
I got them all written down. I don't have them in front of
In
me.
between, well, Mr. Flores, in between the 6 to 8 months between now, you interacted with Mr. Jones or?
No, I avoid Mr. Jones.
Well-
Mr. Jones interacts with me.
Okay, so during these 6 to 8 months, he interacted with you. What were, some of the things that he was saying to you?
You punk ass bitch motherfucker, you ratchet ass motherfucker, your mama's a motherfucking honky, a whole lot of stuff.
All right, and at these times, these statements were made, were there other individuals in the hallway?
Yeah, I wrote all that stuff down. I gave it to the boss. The lawyer told me that we were only gonna use the voicemails, and I'm just here.
All right, in between the 6 and 8 months, so you said your, Mr. Jones' interaction with you has caused you to not even want to go to work and feel harassed, correct?
Yes.
All right, and prior to the 6 to 8 months, let me say around, we'll say October of last year, you started problems with
Yeah,
November.
It was still decent outside, yeah.
Okay. And so prior to that period of time, did you ever have any issues with Mr. Jones? Did he ever threaten you?
Nope.
All right, so this happened, were you familiar with him being, having a notice to quit? Were you familiar with McDonald Senior Apartment attempting to get rid of him or remove him from the premises?
The boss told me that she sent stuff to the lawyer, and I said, okay.
All right, about what time was that?
Oh, I
Was it within the 6 to 8 months?
it's whenever she said she filed that paperwork. That's the only thing I can tell you.
And then after she filed the paperwork, you continued getting threats
Yes.
from Mr. Jones? All right. You can get the question. I nailed on the time frame, so between 6 to 8 months, go ahead and you know.
I'm just saying, it's just, I mean, I'm hearing what you're saying to him and I'm hearing what he's saying to you, but he's not giving you no dates and times or nothing of when none of this happened. And I'm gonna tell you why, because for the first,
Well, Mr. Jones, here's the deal. I've said 6 to 8 months if you were listening. So,
I understand,
I mean, exact dates, he said within the 6 to 8 month window.
tell y'all what I'm gonna do.
You got any more questions, Mr. John?
I'm close.
All right, you may proceed.
You know what I mean? Y'all do it.
Mr. Jones,
Listen to me.
Mr. Jones,
I got all respect for you. I swear I do. No scarcity, I do. But my whole thing about this whole court procedure is I ain't been in trouble in so long, so I don't know nothing about the system no more.
Mr. Jones, let me just say this. You got anything else regarding this case? Any questions?
No, I'm
Any
saying
evidence?
it's over with.
You may be seated. All right, any redirect?
No redirect, and no further witnesses. I would just indicate, your plaintiff would rest subject to the ability to recall for all purposes only.
Did you have any witnesses, Mr. Jones, that you brought here that you with the question?
No, Your Honor, I was gonna recall her, but I didn't even change my mind about that. I'm good.
So you're not presenting a witness or
No.
a defense?
Nope.
All right. Mr. Flores, you may start. All right, you can, take forward.
I guess in the basis of no defense, I've indicated that the determination is appropriate at this point. That being said, I'll have further to indicate that Your Honor has, reviewed the exhibits and heard the exhibits by way of the voicemails that have been embedded in evidence. And heard the testimony of, both plaintiff's property manager and the maintenance director. It's clear, and I think that, the best witness for the plaintiff was Mr. Jones himself by way of his voicemail. So his actions are clearly threatening,
Mr.
intimidation.
Jones, please be seated and stop talking the paper.
I'm sorry.
His actions are clearly threatening in nature, intimidating the community, intimidating the workers there, and causing problems with the ongoing management of the property. We believe, Your Honor, that we're conscious of the evidence we have demonstrated that termination is appropriate in this case. Even though, Judge, there has been no actions taken on behalf of the threats that have been received. I would request that this be a 24-hour writ as opposed to a 10-day writ. Either way, Your Honor decides to choose on that. We believe that we have demonstrated that termination is appropriate in this case.
Mr. Jones, would you like to make a closing argument?
My closing argument. Closing argument, Your Honor, is I have the reason to obtain this is yes. Feel like I'm the one that was being harassed. I feel like I'm the one that I don't believe they proved nothing. They can't prove nothing to no tape. You know what I'm saying? You don't know what kind of state of mind I was in at the time. And you just taking parts of the tape. And I'm gonna let y'all do this. See, this is my closing argument. I'm gonna let y'all do this the way y'all want to do it. And because I still got a right to appeal it. And what I'm gonna say, this is gonna be it. Nothing gonna change. You did what I said?
I understand.
Ain't nothing gonna change. I'll just move or whatever. But ain't nothing gonna change. I'm still live every day.
All right. So, I mean, it's quite clear, at least was looking into between McDonald City Apartments and Mr. Jones. Section 8, subsection B1 talks about behavior that is detrimental to the not only residents but workers of McDonald City Apartments, and also McDonald City Apartments community policies outlined in page 4, paragraph 5. So section B and C, threatening behavior. This case was initiated because we've heard approximately 7 voicemails. The first voicemail was a threatening voicemail. Somebody gonna be fucked up. In today's time and tenor, the temperature of our country and the world, essentially, you just can't call it business and say somebody will get effed up. I mean, I recently had a case where some guys at UWM were being very dumb, and they said it's a bomb in his backpack and sat outside their coworkers, and the coworkers followed through with a terrorism report, and they got filed over circuit court. Folks are not going to sit up here and guess whether or not someone's threats or vocal intonations are real or not. They have a right to feel scared, and that's what Ms. Mcclarkin said. And also, if something occurs at that property, Ms. Mcclarkin is going to be at fault because you made a threat to her that was threatening to the community, and if you follow through with that, at some point in discovery, some plaintiff's attorney is going to find out that Ms. Mcclarkin had a conversation with Mr. Jones. Mr. Jones made this threat, and she didn't follow through, but Ms. Mcclarkin was very up on it. She contacted the police. They filed a report, and then you follow up threatening her. You get a notice to quit. You send more threatening voicemails. I'm very familiar with the McDonald City Apartments, the McDonald family. And so while I've been on this bench, I haven't heard anybody be in this court making threats to that apartment or acting outlandish or anything. I'm sitting here thinking if I ever got a McDonald City apartment case for eviction. I know that community over there, they're elderly, seasoned community, nice people, stating themselves. There's really no issues over there with McDonald City Apartment. And you over here threatening the workers, you got Mr. Flores wanting to avoid you. I think Mr. Flores will avoid you so he won't hurt you. Because you continue to harass him. He's been over there 22 years, about as long as the apartment's been around. I think they've been around 22, maybe a little longer, but I remember, I think right about that around time, 20, 25 years, those apartments been over there. And he's been there to make this man obviously doing a great job. They kept him on, and you over here harassing him, and making threats toward him. You're just a detriment to that community. And keeping you there is, you know, I'm not gonna do that. So it's gonna be immediate eviction. So you got 24 hours to move from there. And also, let me remind you too, you got reported threats that could easily go to the prosecutor's office. You get charged with stalking or aggravated stalking, which is a felony. So you sitting over here acting stupid and being dumb and doing all this, and you walking yourself right into a potential felony case. And I'm not sitting up here blowing you. I know criminal law, criminal procedure. Former prosecutor. I'm gonna tell you exactly how it's gonna go. Complaint warrant, arraignment, PCC exam, arraignment, pretrial, trial, jail, potentially. You made these threats. You said it was you on the calls. I recognize your voice. So get up out of there. You got 24 hours. So judgment for plaintiff against defendant, immediate eviction. So Rick Wade.
I'll say, I'll indicate 4-2 on the order. We'll submit it via my file, Judge.
Yes.
Thank you, Your Honor.
You giving me 24 hours to leave?
You heard me correct. Get up out of there.
Okay, I'm gonna do my best. I'm gonna do my best.
All right.
Rather than 24
I
hours.
suggest you walk out that door before these two officers help you out the door. So take care, sir.
Sir.